Peace to the gods, peace to the gods. Hello, hello, hello. I appreciate that. My culture rules, 10 bones. Thank you for your hard work and dedication to the truth. I appreciate the gems. I appreciate you. Okay, today we're going to have a study session today. First, a couple of announcements. Number one, SBC University is undergoing maintenance right now. I'm tightening up security on that particular site. It will be back up tomorrow. Okay, it will be back up tomorrow. So the site is just undergoing maintenance. Don't get all excited. It'll be back up tomorrow. All right. So today we're going to go over a book that I hold very dear, and I think that will help a lot of people who are interested in this particular subject. And the name of the book is Cracking the Code, the 3rd edition. And the reason why I want to go over this book, because there was a particular section in that book that I think is still very relevant today, and that I have found, I still use some things out of this book to this very day. I still use some things out of this book. And I think that it was very, very instrumental in when I was going through what I was going through and assisting me in getting the resolution I was looking for. And it just had a lot of good, solid information in it. And I want to go through chapter 10 of Cracking the Code. So you don't need to buy it. And no, this is not a jacket. This is a sweater. Somebody saying, well, I get the jacket. Not a jacket, it's a sweater. And you get it, it's free on the internet, this book that I'm going to show you. You don't have to pay for it or anything. It's a PDF version of it. But you can buy it off of Amazon. I have a hard copy that I did purchase off of Amazon, and I would strongly suggest that you have a copy of it and put it in your library, because it's definitely a classic book. Definitely a classic book. For anybody who's in this space, it'd be good to have a copy of Cracking the Code 3rd edition on your bookshelf. All right, let's get the likes up. It's only 59 likes. How many people? 149 viewers today. Okay. And this is going to be a study session, y'all. So I'm going to be going kind of fast. We're studying. I'm going to go through this. I'm going to try to go through this entire chapter. I'm going to be reading it to you. I'm going to be pointing out the salient points that I think that you should be paying attention to. And it should be very educational. That's all I can say. All right, get the likes up. We got 67 likes. Before I begin, let's try to get up to 100 likes. Let's try to get it up to 100 likes so we can help the analytics. Share this on your social media. And we had 84 likes. Let's keep going. 91. Likes up, likes up, likes up. 95, 5 more, and we can start. I appreciate them 10 bones too. All right, 98 likes. I'm just trying to get to 100 likes so we can start. All right, 100 likes. So let's begin. So first and foremost, all right, the name of this chapter is Handling Presentments. This is chapter 10 in Cracking the Code. And a presentment is everything that y'all are trying to discharge. Anything that you're trying to discharge, all the debt that you're attempting to discharge. The debt is really a presentment. And a presentment has more than one definition to it. There's a presentment that a grand jury has for a bill of indictment. And then there's a presentment that you make with a negotiable instrument. And we're going to be talking about those today. And this is basically cracking the code, the process, since everybody likes to use that word, that is being used in cracking the code is the copywriting of the name. That is the theme of Cracking the Code, the 3rd edition. That's another thing. And I will say the copywriting the name has a lot of legitimacy to it. And this comes from experience, not just me from some sort of conjecture or me speculating on something. This comes from direct experience, me having encounters with law enforcement and them asking me, was my name copyrighted? And then seeing how they treated me after they found that it was. Okay, so we're going to read this chapter. So I want you to grab you something to drink. You should grab you a pen and a piece of paper. You should be taking notes. I want you to pay particularly attention. I'm going to be reading through this. I'm going to be stopping. I'm going to be explaining things as we go through it. This is a very, very, I think, very, very good document to read, all right? So let's get to it. Handling presentments. Introduction, understanding presentments. The dictionary definition of presentment concerns both criminal matters and financial matters, and the descriptive terms within the definition of each type are interchangeable. A presentment is either a demand for acceptance or a demand for payment, and is defined as follows. A formal written accusation returned by a grand jury on its own initiative without a prosecutor's previous indictment request. And this is like the presentment that is mentioned in the Constitution for the United States of America. And we have the expert commentary. A grand jury has only two functions, either to indict or to return a no bill. The Constitution speaks also of a presentment, but this is a term with a distinct historical meaning now not well understood. Historically, presentment was the process by which a grand jury initiated an independent investigation and asked that a charge be drawn to cover the facts should they constitute a crime. With United States attorneys not always available to advise grand juries, proceeding by presentment is now an outmoded practice. And I always like to read this because I wanted people to understand how grand juries were supposed to operate. You were supposed to be a grand jury by your peers. Those are the people that knew you in your neighborhood. Now they take it from the tax roll or something like that. These people don't know anything about you. They don't know anything about your real character or anything like that. And they're judging you. And also, I want you to pay attention that when you are using a Black's Law 3rd edition, I want you to pay attention to the fact that 3 is a magic number. Remember in Schoolhouse Rock, 3 is a magic number. Remember that? You should go back and watch that. 3 is a magic number. Everything in their system goes in 3s. Always remember that. Even the third sense of most of these words in the dictionary are going to be the commercial sense of the word. All of the words in the Black's Law Dictionary have multiple senses, different meanings, but the third sense is usually, not always, commercially related. I want you to remember that. Now let's look at the next definition. The formal production of a negotiable instrument for acceptance or payment. Now this is important for you to remember when you're attempting to discharge debt or you present someone with a negotiable instrument for set off of an obligation by attempting to use private credit to offset a public liability. You have to remember they just can't say we don't take this kind of payment. That goes against public policy. HJR 192 of June 5th, 1933, Public Law 73-10 and all associated policies requires that or basically mandates that they cannot require you to pay any debt in any particular species of currency. So when you make a presentment, okay, like a promissory note or a bill of exchange, they have to take that and process it and then come back with either a protest certificate saying there's insufficient funds or at least be able to demonstrate that there's some sort of defect in the instrument and allow you an opportunity to cure the defect. All right, so understand that. Presentment, we have to understand what a presentment is. Presentment is a demand for acceptance or payment made upon the maker, acceptor, drawer, or other payor by or on behalf of the holder. All right. Now, a maker is usually dealing with something with a promissory note, and a drawer or drawee is dealing with a three-party instrument like a bill of exchange or a check. Okay. So understand we have bills and notes. There's a chapter in American jurisprudence that is devoted to that. It would be very, very wise of you to study that if you are interested in any kind of way with negotiable instruments. There is a PDF copy of that available on SPC University in the PDF section under American Jurisprudence folder. All right? So let's get into it. In criminal matters, a bill, namely charges, and we have to write down that word charges. I want you to understand what a charge is. The fifth sense of the word of charge in a Black's Law Dictionary is going to tell you that it is a lien, like a charge on property. So I want you to see how this play that they use on the words in the dict, they have multiple meanings. So you don't know what they're talking about. And that's why when you're in court, you always got to ask questions. A lot of you just jump the gun and will ask a question acting like as if you know what they're talking about, and you don't know what they're talking about. If someone asks you, are you a U.S. citizen? Well, I'm sorry, ma'am, but could you please define U.S. citizen and please tell me where you derived that definition from? Okay, where did you get the definition from? How do you define U.S. citizen? And show me so I can look and check behind you and make sure it's accurate. Everyone in the public has to have a delegation of authority, and they need to be able to show you where it came from. When they start just pulling stuff out of their ass, that means they're operating privately and they lose that immunity. They only have immunity as long as they act within the ambit of delegated authority. These people on these other channels, especially these lame-ass attorneys, they'll try to give you the impression that you can't ask these people. Think about this, y'all. How is an attorney on these other sovereign citizen fail videos going to give you the impression that you can't ask a public servant a damn question? When you come into court and I'm asking you what jurisdiction you're operating under. Like they act like it's something wrong with that, and it's sitting there right in the Sixth Amendment for the Constitution of the United States of America. We have the right to know the nature and cause of any action. Not just the cause of action. They try to act like the cause of action is the nature. The cause of it, oh, well, you got charged with X, Y, and Z. Those are the list of charges, man. It's not what I'm talking about. I'm talking about the nature of the charges. Is in the nature civil or criminal. You can get a traffic ticket, and there are traffic tickets that are civil, Mr. Attorney, and there are traffic tickets that are criminal. You just telling me I got a traffic ticket is not telling me. That you can say you're going to give me contempt, Mr. Attorney, but that's not, they have civil contempt and criminal contempt. What's the nature of what you're saying? So let's keep going. In criminal matters, a bill, namely charges, a bill of indictment with a now think about this. They give you a bill and put charges on it. This don't have nothing to do with commerce. It don't have nothing to do. You just read an indictment. Everything in there is commercial. When they just steady trying to tell you, well, it's not anything commercially related. But here's your bill of indictment with your list of charges. Oh, I'm going to get you motherfuckers. I'm going to get you motherfuckers. Y'all fuck with the wrong. Yeah, let me tell you something. You know who I'm talking to out there. You watch him and you know who you are. You don't fuck with me. Do not fuck with me. It's a mistake. I don't stop. I come harder. I'm setting up a new studio, new equipment. I got all kind of stuff. I'm finna start busting at y'all ass. Let's keep going. In criminal matters, a bill, namely charges like financial charges in the form of a formal written accusation of a crime called an indictment, which is a presentment. When they hand you an indictment, it's a presentment. When you're ever in court and you're in like when you get to arraignment, and they say, how you plead? You say, Jan, I'll be more than happy to enter a plea in the record for it. And I go and watch individuals on YouTube attempt to do this, and they just fuck it up. All right, you got to commit what you're going to say to memory. I think some of this stuff is just set up to look fucked up. So when y'all go over there and watch it, you can watch a guy, he's attempting to use this in court. And I'm like, that's not how you say that. But what you say, Jan, I'll be more than happy to enter a plea into the record on these charges, but I haven't seen any charges formally entered into the record. I see no charges. They're going to walk you over your charges. You're going to look at it front and back. You're going to hand it back to the person who gave it to you. You're going to say, I see no charges. Your Honor, I request that the Honorable Judge demand the prosecutor to read the charges into the record. See, this is all about liability, and they're trying to escape liability. Everything dealing with this is liability, and everything they do is to avoid liability. Everything they do is to avoid. They want to send you to prison, get your money, do whatever they're going to do with you without liability. Somebody is liable for bringing charges against you. Someone is liable for putting you in jail. Somebody got to pay. Let me ask you, Mr. Attorney, what happens if you lock me up for 6 months and I'm innocent? I didn't do nothing. You made a mistake. I should just be happy I'm free, huh? Nah, and see y'all, then y'all give them that little paltry $1 million. No, you know, that's $100 million. That's $200 million. See, I'm going to tell these people the real deal. You don't settle. Them people that be in jail for 20 years and they found they didn't rape nobody and let them out and they give them $1.5 million or something. They are screwing them. They owe them $100, $200, $300 million, man, $500 million. Y'all ain't asking for enough. You got to make that money high if you want to get them to stop fucking with you. $1 million ain't nothing to these people. Ain't no money. They write $1 million bonds all the time behind the scenes. You be tripping out if you see the amount of these bonds behind the scenes. Them like $1 million like $1. So let's go. A true bill is a list of charges that is sworn true, correct, and complete, like an affidavit. Remember, everything in commerce has to be sworn to under penalty of perjury. Nobody can bring a debt against you. That's how you get the debt collectors, the third-party debt collectors. If you're in court and somebody's saying, well, you know, third-party debt collector then held you in the court, all you do is you go in and Yana, you know, I request he take the stand and sworn to penalty of perjury that he is a creditor. They stay away from swearing. That's the next thing you're going to find out. They don't want to swear to anything. They don't want to put, and they won't put an app. They want you to do it because why? Because of the maxim. Anything you say can and will be used against you. So the person testifying is in the inferior position, and the person asking the question is in the superior position. This is why you always answer a question with a question for clarification. Get them to testify. So, based on the sworn charges of the grand jury, the prosecutor is indemnified for whatever action he takes based thereon. The prosecutor then draws up his own presentment called a criminal complaint based on the indictment, which is a true bill, and demands that the named party accept responsibility for the charges. Be careful with the indictments. Always make sure that the grand jury foreman's name is legible, because they will rubber stamp some of these indictments, and as long as they get you to plea out, it doesn't matter. You got to understand, you got to pay attention to your paperwork, because there's another maxim you have to understand: a guilty plea kills all known and unknown defenses. So if you plead guilty to something, it don't matter if they did something corrupt with the paperwork or something. You just admitted you guilty. All right, thank you. All right, so let's keep going. Because of the U.S. bankruptcy and the institutionalization of fiat by decree money called Federal Reserve Notes, FRNs, there have been commensurate changes in the realm of jurisprudence. American tribunals are now Federal Reserve Note tribunals, and this is when this color of law comes in. See, to have real law, you have to have real money. There isn't any money. There's no real money. They're using Federal Reserve Notes. How can you? That's why there are no common law courts. Because the money they charging you with is not constitutional. So how can it be a constitutional court? How are you going to give me a traffic ticket for Federal Reserve Notes, and in the Constitution it tells you the debts can only be paid in gold and silver, but you right there in court trying to pretend like this is some court of law, trying to pretend like this is an Article 3 court or some type of judicial proceeding, when we know this is a territorial court operating outside the Constitution. Well, let me qualify that. Within the ambit of their delegated authority, where they have plenary power according to Article 1, Section 8, Clause 17 of the Constitution. These are Article 1 courts. Article 1, Section 8, Clause 9 gives your legislature the authority to institute tribunals that are inferior to the Supreme Court. And they do it on the state levels too. Separation of powers is not just on the federal level, it's on the state levels too. They mirror each other. So this is a color of law. So American tribunals are now Federal Reserve Note tribunals dealing exclusively in Federal Reserve notes and enforcing the private copyrighted corporate policy of the owners of the Federal Reserve notes, known as code. All U.S. code law is copyrighted British corporations. See footnote 13 at the bottom of the page 41 for details. Now, that's the thing. These are codes. Code, you violated code section. What do you mean a code? This is what we're doing. We're cracking this code. They keep telling you these codes are laws. I got a book where a law professor, I got to find it, where he tells you right in the book, he said statutes are not real laws. They have the force of law because they operate within a certain jurisdiction. And if you're subject, like it says in the Constitution, subject to their authority, then those laws do apply to you. And the evidence that they apply to you is the fact you got a social security number. That social security number and all the other minimum contacts by way of that. So that social security number is evidence that you are a beneficiary of benefits and privileges. You're an acceptor of benefits and privileges. That's an implied contract with the state and the federal government. So notice in the quoted case under the first definition above that because of the influence of United States attorneys, proceeding by presentment of the grand jury is now an outmoded practice. Now, this is very interesting about these grand juries because you got a right to voir dire, which means to tell the truth, the grand jury. And if you don't get an opportunity to do that, you can void the indictment and come back and make them redo it all over again. This is what an abatement is all about. You don't even get to bring, they don't have nobody even on your side even there when they get, it is so rigged. It's rigged, man. I'm trying to tell y'all. I done seen it firsthand. I know if you're an attorney, you know it's rigged, man. Come on, man. Y'all ain't taking all them indictments in front of a grand jury. Who you fooling? Fooling everybody. Y'all rubber stamping a lot of that stuff. Let's keep going. We now operate in a summary proceeding in the vast majority of legal undertakings in America, traffic court being the most common. Summary, what is a summary judgment or summary proceeding? Any proceeding by which a controversy is settled, case disposed of, or trial conducted in a prompt and simple manner, without the aid of a jury, without presentment of indictment, or in other aspects out of the regular course of the common law. All right, so with summary proceeding, which means usually that, it just goes pretty quick. So let's look for a demand for acceptance. A demand for acceptance is a demand for acceptance of responsibility. This is what they even do in the feds. They will give you 3 points when you accept responsibility for payment or for performance of some act, and may also entail payment of some kind at a later date. A traffic ticket is a combination criminal and commercial instrument. The traffic cop makes a demand and the motorist makes a promise. Traffic tickets are negotiable instruments, and negotiable instruments consist strictly of orders to pay and promises to pay. That's what a 3-party instrument and a 2-party instrument. A promissory note is a 2-party instrument, and a check or a bill of exchange is a 3-party instrument. There's an order paid to the order of, or you have a promise to pay. The cop issues an order for acceptance of responsibility to pay against the credit of the trade name. And the motorist signs a promise to accept responsibility for the charge and appear, and, if necessary, pay the ticket. If the motorist fails to accept responsibility for the ultimate payment of the ticket at any point in the process, he is arrested and jailed. When anyone in government demands that you accept responsibility to perform some act, he is issuing a presentment concerning which there are monetary charges associated with a failure to perform. Presentments come in oral, written, and electronic form. Acceptance of any presentment executes a contract. And this is when you also get into Byron Beer's, what does acceptance for value mean? It gets into that play implied contracts, and it's a very, very good book. Definitely something, if you are interested in this, that is required reading. What does acceptance for value mean? By Byron Beers. Required. I don't think it's optional. If you can't understand that book, you probably shouldn't be discharging debt, because it's explaining how private credit comes from the private into the public and the obligations on each side. What type of rights what type of rights the public is getting by giving your signature, and what kind of rights they're giving you by you giving your signature. There's an exchange of rights on both sides, and you need to understand that play. In the private sector, presentments usually come from attorneys. But since all attorneys are officers of the state, we are faced with essentially the same situation. Courts could not function without attorneys, who are endowed with a special property right, the right to practice law. Granted a title of nobility, they call them esquire, and we're not supposed to have titles of nobility in the United States, via letters patent, and elevated above common men. Fees enforced by judicial decree, win or lose. Now, if you're an attorney listening to this, you say you have a license to practice law. I've never seen a license to practice law. I've asked several chief judges to show me theirs, and I haven't been able to see one yet. Now, we did do some investigation on this license to practice law in California. We sent, and you can do this as well, we sent a money order for $100 to the Bar Association with a list of attorneys' names and asked for their copy of their license. They wrote us back, said, we don't issue license. They said the Supreme Court issues the license. So we wrote the Supreme Court. We sent the same $100, they sent the money order back. We sent them another $100 money order asking for copies of a certain attorney's license who practiced law within that state, and they wrote us back, and they said, we don't issue license. So after further investigation, what I found was that there's an implied license of sorts, because the Supreme Court grants them the right to practice law in these courts. It's nothing formal, because if there was some license, we'd have to ask, well, what agency of government issues these licenses for you to practice law? If you're an attorney out there, please tell us what agency issues the license, because you always hit us with that, well, you don't have a license to practice law, which is permission. Okay, how you respond to that, you say, I wasn't aware that the practice of law could be licensed. Just hit them back with that. So let's keep going. In order to issue a presentment, a prospective issuer must have an account where a charge can be lodged. Now, they put a lien against your name. This is like here in Georgia, we have OCGA 1711-1. That's official code of Georgia, annotated under the criminal procedure, where when they find you guilty, they put a lien against you. Okay, what are you putting a lien against? The only thing the government can put a lien against is your social security number, because that's the only nexus that you have between you and government. What else do you have? Everything you get goes through that social security number, your driver's license, your job. If they're gonna garnish your wages, how do they do it? Through your social security number. When your baby mama want to put you on child support, what do she need? Nigga, put that social security number in a safe. Because she gonna go through your wallet. If you hitting her, let me tell you something, young man. If you sleeping with that girl, she gonna go through your something, and y'all ain't no kids, and y'all having unprotected sex. If she intelligent, she gonna find that social security card and write that number down. That social security number. That's what everybody wants. If you get pulled over by the police and you don't have your driver's license, what's the first thing gonna come out of his mouth? What's your social security number? You can give that if you don't have your license. You say, yeah, I don't have my license on me, but you're more than happy to get, here's my social security number and look it up in the system. You can find me, because they can just pull you up through your what? Social security number, and find your license and all the information they need about you. They'll still write you a ticket for not having it, though, just to fuck with you. I'm not going to read these footnotes. You can read those on your own. In order to issue a presentment, a prospective issuer must have an account where a charge can be lodged. For example, if police cannot determine the trade name of a detainee held for questioning within a brief period of time, they must release him, usually in 72 hours. A lot of times they don't follow that though. Just gonna tell you by experience, you know, a lot of things you try to do, they make it real hard for you because they're really supposed to, if they can't identify you through your fingerprints or something like that, they're supposed to let you go within 72 hours. They're really supposed to take you straight before a magistrate as soon as they arrest you, but they don't do that. The reason they fingerprint you and take your picture and run your name before they take you into court is they have to verify that you are indeed a U.S. citizen because they're taking you into one of these color of law courts. So they have to determine if they have jurisdiction over you first to bring you in that kind of court. You ain't going into a common law court. Think about it. How are you fingerprinting me and taking my damn picture and I haven't been found guilty of nothing, nigga? You can explain it however you want to. So let's keep going. The trade name is an account name under which a sovereign conducts business, albeit unwittingly. That's your account number, your social security number. The trade name as well as the true name comprises property. Write that word down, property. You need to know, give a clear understanding of the definition of property. Because a lot of you, I think the first thing that pops into your mind when you hear the word property is real estate. Registration of the trade name via birth certificate, etc. Now, I don't agree with this right here. When you're in the hospital, the first thing they want is the birth certificate, and then they come right behind you trying to get you to get a social security number for your child. The social security number is optional, it's voluntary. They'll send about 5 nurses in there to put pressure on you to get it. Tell them to fuck off. They say, well, you know, you're a doctor. Say, are you? Doctor ain't never gonna be in there, it's gonna be nurses. Registration of your trade name via birth, etc., constitutes a voluntary surrender of custody of the property, the name, and establishment of an account. That's why they want that to give you that number. If you don't give them a social security number, they couldn't put no account in the system for you. That's what I did for my son. My son was born. I said, no, why you want my son don't need no social security number? I said, my son, social security is so you can take money out of his check for his retirement. He can do that when he get older. I don't want shit from you. I don't need to claim them on my taxes or nothing like that. I make too much money. I'm not claiming my kids on no damn taxes. I don't want shit from you, nigga. My son need an advantage. And I'm not going to disadvantage him by putting him in your system and you're already hunting them down and shooting them down like dogs in the street. The trade name as well as the true name comprises property. Registration of your trade name via birth, etc., constitutes a voluntary surrender of custody of the property, the name, and establishment of an account. When a government actor says, may I have your name, please, he is literally asking you to turn over your property, the trade name, for him to use however he pleases and to charge the account. That's why in court they want you to state your name for the record, and if you don't give it to them, all hell gonna break loose. Oh, you're gonna not fail to appear. You can't say I'm here concerning that matter anymore. You can't just say that because they're gonna start pressing you. Are you this name? I did that to a judge because you can do it to them. You say, Your Honor, I request it. He say, you know, Your Honor, may I have your name, please? Judge so-and-so, I'm sorry, Your Honor, your offer of communication is accepted for value and your dishonor is returned. May I have your name, not your title, ma'am. Because when I go and get your oath of office down from the Secretary of State, it doesn't have Judge so-and-so on there, it just has your name. I need that name, so I need a name that I can lodge in a commercial registry as well. Just like you're trying to do with me, I need your name to do the same thing. Equality under the law is mandatory. What's good for the goose is good for the gander. You want to play the game of commerce, let's play. So state your name for the record also. Because when you get a transcript, their name ain't going to be on there. It's just going to say the court. That's one way of avoiding liability. It just says the court, the court, the court. Read a transcript. Get them to state their name for the record too. May I have your name? You need it on the record. Your Honor, I request that Your Honor direct the prosecutor to place the serial placement of his bar card into the record, please, sir. That's a bond. So you're conducting business with this trade name. That's why it's in all caps. When you look at that social security card number, look at your social security card. Pull it out right now. Look at it. Look at it. It's in all caps. Pull your driver's license out right now. Look at it. It's in all caps. Look at it. Pull that utility bill out right now. Look at it. It's in all caps. Look at your bank statement. It's in all caps. And they'll sit there and tell you, that don't mean nothing. Even though I can't find anywhere in the rules of English grammar that allows for that practice. And everything in law is science. Everything. Obviously, accept that practice. There's no scientific explanation. You just do it. Let you tell it. Okay. When a government actor says, may I have your name, please, he is literally asking you to turn over your property, the trade name, for him to use however he pleases and to charge the account. The flesh and blood man, as surety for the party in whose name the account appears, is held accountable for any charges levied against the trade name. Now, I want y'all to understand something. The reason they're playing this game is because they're bankrupt. Y'all have to understand this point I'm about to tell you. The reason why the first rule is there is no money, because you have to understand the creation of what they call money is through debt. Debt creates money, so they have to create obligations. That's why the bank wants to always constantly repossess property and then make new loans. They're creating money through new loans. That's why they'll never allow all of you to pay off all your mortgages in the United States, even though I'm going to attempt to provide a way for y'all to do that. We're currency circulator. I want to test that theory. So when you give them your name and you sign something, that's like signing a check. They got your social security number. They ain't going in your account. A lot of y'all, well, they're going in my account. They're not going in your account. They put in a lien against your account. A lien is evidence of a debt. They can take that lien and sell it on the market. That's how they fund themselves. They're not going in your account. They don't have to. That's not how money works. They just need to create an obligation. How do you think all these people are making money? I remember one time ADT was at my house installing my security system. And the guy there, he was sitting at the table. He was a representative. He said, I don't understand how ADT makes any money. We just come out here and install this and don't charge y'all nothing. How do you make any money? I said, I know how they make money, because I got to sign a 2-year contract. That 2-year contract is I'm locked in an obligation to make these payments every month for 24 months. That piece of paper now has value. Let's say it was $100 every month. That's $2,400 that I'm promising to pay. They can go to the markets and say, hey, look, we got a guy right here over the next 24 months. He's promising to pay $100 a month, and this contract is worth $2,400. If you give us $1,000 right now so I can put it in my pocket, you can have the contract, and I'll get out the way. That's called discounting paper, discount paper. They do it in real estate. They do it all over the place. That's how they get their money. Money changing. The reason the criminal and financial charges seem to run together, overlap, and mirror the other is that they are both commercial in nature. We know 27 CFR 72.11 states all crimes are commercial, federal and state. This is the admiralty jurisdiction mentioned in Part 1 theory of this manual. In admiralty, the military, in its many forms, is used to enforce criminal penalties for civil offenses. The money changer merchants have foreclosed on the U.S. government and use it liberally to prosecute their own private commercial interests. We are under military rule, literally by the commander-in-chief of the military, not the president. And this is the really interesting thing, too, about that, about admiralty. They don't call it admiralty. You got to understand that they don't call it. It's commerce is what they're using. They call it civil because admiralty is civil in nature. But admiralty has a criminal aspect to it, too. See, when you study the history of this, you're going to find that the common law courts and the admiralty courts have been vying for power for the last 1,000 years, probably. There's been this play, sometimes the common law courts rule for a certain amount of time, and then sometimes the admiralty courts rule for a certain amount of time. But this goes back to all the way back to England and how each baron and people, lords, landlords, when we were in a feudalistic, when they had the feudalism going on, them guys, those landlords would have their own courts. So you see the same thing with the counties today. If you notice, these counties are all named after people. It's a form of feudalism going on today, too. It's very, very similar. These people don't just create things and pull it out their ass. They follow the roadmap of their ancestors, and then they modernize it. They just modernize everything. They're not that intelligent to create something from scratch. Everything they're doing is built on centuries of precedents. Centuries. And when you study history, you can see it clearly. That's why those guys look foolish for some of the things they be saying. I'm like, man, you sound crazy. This is not admiralty. Admiralty is the law of the sea. Well, if you took the time to do a cursory investigation of the subject, you would find that, yes, it is the law of the sea, but it deals with the subject matter, not the locale. People ain't making contracts out in the middle of the sea, fool. It's doing with commerce. 90% of commerce goes over the ocean. The other 10% goes over land with the trucks. But it's all connected. You got to really see how they have changed the meaning. They're acting colorably. It's called a colorable admiralty jurisdiction. Colorable. It's not real admiralty. It's colorable admiralty. They're copying off of it. Yana, is this civil or criminal? Well, it's criminal. Thank you. Let the record show that the action being brought against the defendant is a criminal action. Now, sir, I have another question for you. The Constitution for the United States of America only grants this court 2 criminal jurisdictions. One is under the common law, and the other constitutes a condition of contract under criminal aspects of a colorable admiralty jurisdiction. Now, sir, for the record, would you please tell the court and myself under which 2 of these jurisdictions this court is trying this criminal action? Read the clerk's praxis. It'll be up on the PDF section of the website when the website comes back up. Quick announcement, once again, in case you weren't here at the beginning, SPC University is under maintenance. It will be back up tomorrow. So don't get all excited. It will be back up tomorrow. A primary reason for the broad appeal and workability of the common law is that each man is in control of his own destiny in the social scheme as long as he does not harm another and thereby form a contract with an obligation. He is free to live his life as he sees fit without interference from the government. Now, this is a really interesting thing. And they got a website on Justia that explains this. You have a right. They say, well, these sovereigns think they don't have to be under any law. Well, that's what privacy is, fool. This is called a free country. What you don't understand. I'm not the one that, this ain't your country. This is country we the people. These are codes that you trying to enforce upon people. These ain't laws. The common law ain't went nowhere. The common law is the foundation of this country. If you're saying this is what they'll try to tell you, that things have changed. Okay, when did it change and how did it change and why did it change? I'm waiting to hear an explanation. You're saying we're no longer under the common law. Give me a concise, cogent explanation of when did it change, why it changed, how it changed. Write it out for me and explain that. As a matter of fact, when you go over there on your Sovereign Citizen Fail videos, make sure you explain that to your listeners. Well, we're no longer under the common law. Well, how? When did it change? How did it change? Why weren't we informed? Did we agree to it? How did we agree to it? So we're not under the common law anymore. And I'm not going to say that the common law was real strict. Okay. A lot of people, like, they want to be under the common law. A lot of stuff wouldn't be going on if we were under the common law. You wouldn't be having gay marriage if we were under the common law. Women wouldn't just be willy-nilly divorcing people and remarrying 2 and 3 and 4 times. There's a lot of things under the common law that would not be occurring. You're able to do this in this legal environment that they have right now. You can get married legally, but under a common law marriage, that's something else. But legal marriage is another thing. So a lot of people talk about going back to the common law, but I don't think a lot of people really want to go back to the common law. I think some of you are better off learning how to operate in commerce. Just saying. So a primary reason for the broad appeal and workability of the common law is that each man is in control of his own destiny and the social scheme, as long as he does not harm another and thereby form a contract with an obligation. He is free to live his life as he sees fit without interference from the government. These days, however, people are penalized for an act even when no one is harmed and no property is damaged, namely traveling at 35 miles per hour in a 30-mile-per-hour zone. The police power is thereby employed for penalizing behavior such as thought crimes, not acts and deeds of substance, for the purpose of raising revenue. Because, you know, we know y'all police officers out there, y'all ain't nothing but revenue agents. And the thing is that you have victimless crimes. Now, explain that to me. Okay, how can you have a crime and ain't no victim? And they gonna try to explain it to you and make it make sense. This that Wizard of Oz shit. You know, it's well, of course, you know, there's no victim. This the state. The state. We don't have a right to face my accuser. Yeah, well, I call the state to the witness stand. Can I call the state of Texas to the witness stand? Well, I ought it. They're in the land of fictions and frauds. These are legal fictions. They deal in fictions, and they try to pretend like they don't. Oh, they want to believe that the all caps name is some type of straw man. Nigga, that's all you deal in is fictions in the public. Corporations. Titles. Man, you think people are stupid. That's the real issue. You just think everybody is stupid. That's why I be getting pissed off. I got this dumbass in front of me trying to make me seem like I'm stupid. Okay. But you believe that you can commit a crime, ain't no victim, but I'm the stupid one. Okay, let me regain my composure because this shit be funny, man. Let me tell you something. If you really start studying, this shit be hilarious, the shit they be doing. When you start seeing the truth, when you turn on the light on their ass, you're going to see them start scampering like roaches. They scared you're going to turn on that light. That's why when you look Sovereign Citizen Fail, they got 1 million motherfucking videos on the internet. 1 million. Let's keep going. All right, let me keep going. When someone violates his own sense of moral rightness in his conduct as a member of society, no matter how justified, he is weakened under the police power of the state. For this reason, it is a good idea to reassess your life as you embark on this stage of the journey and begin using and relying on the power of the documents and processes offered herein, which is formidable. And make sure that you're giving yourself the best chance for a worry-free existence. Betraying your own sense of fair play is the quickest way to undermine all processes. In the end, it is your own self-decency, ethical behavior, and interaction with others that determines your fate. This is what we mean by staying in honor at all costs. A lot of people, you want to be involved in these processes, and then you're not an honorable person, and then you're expecting some sort of remedy. And equity these are equitable remedies. And to get equity, you must do equity. That's one of the principles of equity. You have to have clean hands and operate in good faith. You ain't just automatically entitled to a remedy. A remedy is a right, and in commerce, it's a commercial right, which means it has to be expressed in the form of a contract, which is why we do administrative processes. Letters are contracts. Negotiable instruments are contracts. Just go read bills and notes, very first paragraph. Negotiable, it tells you very first paragraph, first sentence. Negotiable instruments are contracts. So you're discharging a contract. If you get a Black's Law 4th edition and you look up the phrase discharge of contract, you're going to see 14 different ways to discharge something. Set off is a form of discharge. That is the one we're using. A lot of y'all say, I want to discharge a debt. Well, how are you discharging it? There are like 14 different ways to discharge a debt. Paying for something is a discharge. We're not trying to pay for anything. We are setting off. We're using a set off. And it would behoove you to use that more than the word discharge. I don't like the term discharge debt because it's vague. So, let me read this. In the end, it is your own sense of decency, ethical behavior, and interaction with others that determines your fate. Just by trying to do the right thing on a moment-to-moment basis brings about clarity of perception not otherwise available. And also, there's a maxim of law: for you to be guilty, the mind must be guilty. It has to be criminal intent, mens rea. You have to intend to do something. That's why they do an examination and a cross-examination. What are they examining? An examination is a direct examination into your mind. A cross-examination is an examination into the subconscious mind. For you to be telling the truth, the conscious and subconscious have to be in harmony. Now, I will give attorneys credit. They are very trained in getting that information out of you. That's why it's very dangerous to go to trial and you're not an innocent. Trial is for innocent people, not people who are looking, well, I don't think they got enough evidence against me, so, I'm going to take it to trial. He didn't do that right. Your ass is going to get locked up. Because that ain't how this go. You should be living honorably with your fellow man. This ain't for murderers and people who like to break in houses and people who want to sell drugs and people who want to drive through a school zone at 70, 80 miles an hour. Because if you hit my child, I'm going to the common law. I'm going straight to the common law. I'm going straight to the common law. An eye for an eye. Let me tell you something. If we were in the common law, there would not be a lot of the crimes that are going on right now. There would not be this rampant immorality that is going on right now because the penalties are so harsh. That's why you don't have a lot of this going on like in Muslim countries, because they follow the Sharia. All the laws of the country go off of the religious texts of that country. The laws in the United States of America derive themselves from Blackstone commentaries in the Bible. And they want to get rid of your belief in God. They don't want you to have nowhere. When they get rid of your belief in God, who you going to turn to? You got to turn to them. They become your God. They become the ultimate authority. These people want to be God. What do you think it was talking about in Isaiah chapter 14? I will be like the Most High. And people will narrowly look upon thee and consider thee, saying, is this the man to make the earth tremble? That's what the Wizard of Oz was all about. They were terrified of the wizard. They looked behind the curtain. It was this weak, sickly man terrifying the whole country. That's why they say when you find out the truth, you're going to laugh. What do you think creditors in their bond says? It only hurts when I laugh. When you find out the truth, it's going to be funny. I've been afraid of who? What? O ye of little faith. These documents are based on the power of the common law, private property rights, and consensual contracts, and are enormously successful in crushing assaults of your fiscal integrity. Their efficacy has been acknowledged at both the lowest and highest levels of government in this country. They have changed the course of everyday proceedings in which they were introduced, including criminal cases where the accused was already convicted. That is because the common law still exists and is in full force. It has just been covered over, and that's what I tell people. They say the Constitution ain't been applied. You sound like a damn fool. The Constitution ain't went nowhere. The Constitution is where these people get their delegation of authority from. The organic Constitution and the common law is still around, right and intact. You just ain't using it because you ain't in the Republic, because you want to roll with the Democrats. I was listening to The View today. Them ain't nothing but that's nothing but a show full of Marxist, communists, socialists, old-ass women. You know, we Democrats need to fight against, they call us communists and socialists. You are communists and socialists. Why don't you explain to the people what communism is? Why don't you read them the Communist Manifesto? Why don't you do a study on that and then compare it to what the Democrats are doing? And then you will understand why we call you communist and socialist. Y'all inundating these commercials on YouTube offering government benefits. Stimulus checks. That's socialism. Social Security. You established it in 1933. That was the establishment of the welfare state under Franklin Delano Roosevelt. What are you talking about? 72 members of his cabinet, which were appointed, were Jews. That's a piece of history. They trying to erase that off the internet. I got it on one of my videos, the list of all the names too. List of all the names. I'm gonna dig up the video when they took it down off the internet. Have all 72 of their names. And they still got doing it today. 70% of your government right now is Jewish. Now, listen, this is no indictment against Jews because we're talking about Zionism. However, don't you think it's strange that Karl Marx is Jewish, he's a Zionist, That you have people like Joe Biden openly calling himself a Zionist. You can pull him up on YouTube right now. Joe Biden is a Zionist, and listen to him say this clearly out of his mouth that he's a Zionist. That you have your Secretary of Treasury, your Attorney General, what is it? I think the ATF. All of these people are Jewish. The person over your health and human services, I believe he's a transgender Jewish and a 4-star general and a transgender. And most of y'all don't even know it. Okay, so I'm not here against anyone. However, hey, look, you start connecting the dots and it's like, okay, well, they are the people who created socialism and communism. Communist Russia was what? In control of Jews. The Soviet Union was established by Jews. So let's read A again. Let's start right here. So right now we're talking about these documents. So these documents are based on the power of the common law, private property rights, and consensual contracts, and are enormously successful in crushing assaults on your fiscal integrity. The efficacy has been acknowledged at both the lowest and very highest levels of government in this country. They have changed the course of every proceeding in which they were introduced, including criminal cases where the accused was already convicted. That is because the common law still exists and is in full force. It has just been covered over. I have a girl right now. She just got her case overturned and immediate release. And everybody in the government, our attorney keep telling her, ain't nothing like this happened before. And it's on the federal level too. I'm waiting for her to get out. They trying to, right now, she said, they supposed to release me, but they ain't released me. He said, the marshals are coming to pick me up, but they said they want to come pick me up and all of this. I said, yeah, somebody's liable for that. There's liability that is being discussed. Who's liable for this? And it's based off the fact, what she told me is that she took it to the appeals court because she asked for the nature and cause of the action. And when they took that to appeal, the government just dropped it. They got to tell you what the nature of the charges are. If you ask, they're going to probably bullshit you, but you got to call them on their bullshit. And you have to be good at doing it. You have to be good at doing it. You have to be able to anticipate their reaction and how they're going to answer. You have to be able to anticipate that and be prepared. Thank you for the donations. People have been so badly hoodwinked that many do not even believe there is hope of reversing the oppressive, all-engulfing practices of the system. There is hope. It lies in the common law and in your ability to maintain in the face of the mendacious bent of big brother operatives. I love this document. It has so many good, whoever wrote it has such a good command of the English language and uses a lot of different words. It's actually very, very pleasant to read, something like this. Scope of presentment handling documents contained herein. What has taken many thousands of dedicated collaborators over thousands of years to put into position will not be fully unraveled in a few hundred pages of exposition, nor do we pretend to be able to fully accomplish such a feat. We do, however, get results, and consistently, because our approach is based on the timeless principles of human dignity and interaction as embodied primarily in the common law. And that's why, as human dignity, the common law is strict. You're not going to just rape someone. You're not going to take somebody's virginity and not be responsible for them. We got to get back. Let me tell you something real quick. You got to get back to men. Nothing's going to change with the state of relationships in the world until you get back to honoring virginity. A woman's first sexual encounter is the most important event in her life. And that is why a lot of your marriages and things are not working, because these women are sleeping with multiple men. And they try and making you think that, oh, this is natural for us. No one wants just one person either. She only thinks like that because she's been introduced to something that is unnatural. Our families and everything depend on it. And you can get offended by what I'm saying. But once you understand that, if you see in the Bible it tells you to do something and you go against that Bible, claiming that, oh, that don't mean nothing, and then you look at the state of affairs in the world today, and you say, well, damn, you sitting there telling me, well, the way you talking about definitely don't work. It definitely don't work, this do whatever you want to do type of way you talking about. That definitely doesn't work. We got examples all over the place of that failing. This is common law. Common law marriage. Common law marriage was when you had sex. When you had sex with that woman, she was your wife. Because a woman is imprinted by the first man she has sex with. She gets her soul from the first man she has sex with. That is why, if you look at women who get molested, that's why they so loose and things like that, because their first sexual encounter was from a debased man, and they took on a debased spirit. I like my man, he was talking today how every time you ejaculate in a woman, your sperm go up to her brain. The spirit is in the blood, and semen is concentrated blood. You putting your spirit in her. Spirit is composed of thoughts, vibrational frequencies. Why would you ever think that something like that is nonsense? When we break it down in scientific terms, it's the only thing that makes sense. You got to protect your women when they're very, very young. These predators and things like that, that's what's going to make things change. When you start honoring that again, and you start arranging marriages. Dating is not something that ever existed. This dating. They talk about dating. No, it's not courting and all of this. No, you had to present a woman to the father, and he had to approve of it. Because only a man could look at another man to determine whether or not this would make a good prospect for his daughter. Because we can see through the bullshit. They can't. I remember one time my grandma, man, I was in love with this girl, man. It's my first love. It's my first love. And my first love, she was nasty and lazy. She didn't like to clean up. She didn't like to do nothing, It's kind of, but I loved her, you know what I'm saying? Because she was beautiful, looked good. But she was lazy as all get out. And so after dating for a while, because I was in love with her, I took her and introduced her to my grandmother. And I just left her, when we walked in the house, she sat in the chair, and my grandmother, she's very old school. She's an educator. She's an English teacher, real big on education and a whole lot of things. And so she wanted to talk to her one-on-one. They pulled over into the corner, and they didn't talk nothing for about 5 minutes, and I just saw my girlfriend get mad and get up and just leave. And I went rush over to see what was wrong, and she was just pissed off, and she left. And my grandmother, she said to me, "Joseph, don't marry that girl. She's lazy." And I couldn't say nothing because I knew instantly she was right. I knew she was lazy. But for my grandma to be able to determine that in such a short amount of time, that's what fucked me up. I was like, damn, she didn't talk to her 2 minutes, you know what I'm saying? How'd you figure? She didn't broke her down, so fast, it kind of fucked me up. I was like, golly, yeah, you're right. She's lazy, she's lazy, but and she said, don't marry that girl. She's lazy. And it was very good advice. Very good advice. And men can do the same thing, just like how a woman can do the same thing with a woman, can peep a woman game, a man can do the same thing with a man. That's the point I'm trying to make. It's like, they see things you don't see. My mama used to do that all the time, man. My mama used to, man, she could just peep stuff, man, and I don't know where it would come from, but she was like, I used to think my mother had fucking special powers and shit. I remember one time I smoked, me and my friend, we young, we like 15 or 16. Our first time smoke a cigarette. We played hooky from school, so we gonna smoke a cigarette, but we smoking it and blowing it out of the window. And this is about like 11 o'clock in the morning. My mama don't get home until like, 3, 4 o'clock, something like that. She get home and we done sprayed, did everything to get the smell out. And she walk in the door, she ain't been in the house, 2 seconds. Who been smoking in this house? I was like, man, she do some stuff, man, had me terrorized. I'm like, damn. I was like, what? And same thing, she would have that same sense too. She'd tell me things about women and, it'd be just like, how the hell, it's like where it can, but man, she'll tell me something, it's been 100% of the time it's been correct. So when she tell me something about a woman, with my mama, she tell me something about a woman, she break it down and just give me the facts and it never be wrong. Never, never be wrong. So, hey, I'm just saying, I didn't mean to go so long into that, but I was just sitting there thinking about that, you got to start protecting your daughters because the woman is connected to nature before she has her first sexual experience. She has a direct connection with nature. That's why she's the feminine. She is the manifestation of the feminine energy. And that gets polluted, for a lack of a better word, when she has her first sexual encounter. This is why they would have seers and women like that. They were virgins because they had a direct connection with Mother Nature. They had power. I think people think like I go against women and I go bad on women. No, I go bad on whores and things like that. I don't go bad on women. All right, because I understand what needs to be, but I also understand that people haven't been educated about the esoteric aspects of things either. That people are just ignoring the spiritual ramifications of things, and they just completely physical. They think as long as it feels good, it's okay. But no, there's a cause and effect associated with everything. And if you don't know the effect, that by definition is acting in ignorance. So your daughters are important. They're real important, man. They're real important. Let's keep going. Let's go to B real quick. Let me reread it. Scope of presentment handling documents contained herein. What has taken many thousands of dedicated collaborators over thousands of years to put into position will not be fully unraveled in a few hundred pages of exposition, nor do we pretend to be able to fully accomplish such a feat. We do, however, get results, and consistently, because our approach is based on the timeless principles of human dignity and interaction as embodied primarily in the common law. The chosen masters are not pleased with that their wealth confiscation and freedom usurpation machinery has been rendered ineffective, and even more upset that their own device, the UCC, can be used to victimize them. Even when you are completely right, a presenter will sometimes go down kicking and screaming all the way, abusing their influence over the utterly corrupt judicial system and its army of charlatan whore esquires to challenge every shred of knowledge about what you are doing. Because those actors are inherently dishonest, they have weaknesses that can be exploited. Man, this dude wrote this, man. And that's what you're dealing with. That's why it's hard to discharge something. That's why when you're innocent, they refuse to dismiss the case. Because they're inherently dishonest. You're dealing with devils. Revelations 18:2. You warned about attorneys all through the Bible. They don't operate off the same sort of group of ethics that come from like scripture. That's not their ethics. It's a different set of ethics. And, what's a lie? You have to be under oath. If it's not under oath, it's not a lie. Just things like that you have to understand. They do have a different language and a different way of doing things. And you got to understand, it's not anything that is wholeheartedly in accordance with God. Now, when you get to equity, it is. Because equity, that comes from the ecclesiastical churches. That does derive down, that derives down from God's law. Because God judges man with equity. So if he's going to delegate authority to act in his stead on planet Earth, it stands to reason you should be using equity. That's in your Bible. God judges with equity. Equity is fairness, impartiality, and even-handed dealing. We go to the substance of the matter. Where is the victim? What are the rights of the parties? Okay, thank you. Jefferson Tree, $4.99. What's up, Yusef? I don't want to take you off topic. Just put it out there. If you haven't seen the Supreme, well, it's not the Supreme Court Justices. I don't know, SOTUS, I think you meant SCOTUS, Supreme Court argument for Chev defense versus, I don't know. If you got a citation of authority, put it up, man. And give me a citation so I can pull it up. Because I ain't really understanding what you're saying, but you got a citation. Just post the citation. That makes it easy. So let's go. It said, so they got weaknesses that can be exploited. All right. And that, everybody's making money, man. And everybody you meet in the public and private. I'm not just talking about the public. It's public and private. Everybody you meet ain't a good person. Everybody you meet is not an honest person. That's why you got to put on the shield of armor of truth, because once you root yourself in truth, you can be able to distinguish, who is and who's not. But if you ain't rooted in nothing, you don't know nothing. And the reason that you're rooting yourself in natural laws, because natural laws is what empowers you to become a god. Those are the tools that you use to become masters of your environment. The only way to defeat nature is to obey her. Once you start following and learning what her laws are, then you can use those laws to your benefit. You can bend them to your will. But she requires that you give her what she wants first, and that is obedience. That's the way it works. Now, that's a piece of information. I don't care what you believe in. That is a universal principle that I just gave you. That's universal. Ain't nothing getting by that. When I say universal, immutable, it don't matter how you feel about it. Ain't nothing getting past that. Nothing. That's the gateway. That's the gateway into immortality. Oh, shoot. All right, so let's get deep into this. All right. So right here. Now, this is a manual that we're reading, Cracking the Code. This is Cracking the Code, 3rd edition, what I'm reading from. And as you can see, this is chapter 10 of it, and chapter 10 is dealing with presentments. So right now, this is like a beginning, but we're going to get into some document preparation. We're going to be looking at documents in all of this too. I'm thinking about moving this to Patreon, but I don't know. Y'all tell me y'all want me to keep doing it on YouTube, I will, because you can get the document on YouTube. So we'll go through it on YouTube. Fuck it, All right, so it says the documents is offered herein that paved the way for stopping all collection activity affecting strict non-judicial foreclosure. That's what you should start studying, strict non-judicial foreclosure. That's something they're hiding from you. That's part of that self-help remedies. Strict non-judicial foreclosure against those who would happily swindle you out of everything you own. However, this manual does not pretend to be able to guide someone through the legal minefields that can arise when one goes to foreclose. But we do have people who can assist you when it comes time for finishing off that job. That right there is just a declaration that they ain't quite mastered it themselves. It's one thing, and reason why it's hard to master because you're going to battle. And a lot of people don't want to take things all the way. You go into battle. You have to fight for your rights. You have to fight for your rights. It's one thing to be able to stop a collection proceeding. It is quite another to foreclose on the erstwhile forecloser, but it can be done. Instructions for such enterprise are not included herein. However, please contact the publisher for a referral on these matters. This was written about almost 20 years ago. Good luck on that. Okay. A note on pressure situations in criminal cases. I think this is very interesting. The material set forth herein is private in nature. Understand the difference between public and private. There is no attempt to give legal advice of any kind in civil and criminal matters because we are not licensed to practice law. This material may be applied, however, in any circumstance where your private common law copyrighted property is being used for commercial gain without your authorization. Also notice this is common law copyrighted. They said, well, copyright the name is common law copyrighted. There's a distinction. You are the only one who can decide what should be done. If you are faced with a pressure situation, a demand for a signature, or even a criminal charge, you can still take action in the non-statutory, non-judicial realm against the individual players coming against you by using the private, contractual, consensual measures set forth in the items at the end of this section. Beginning at page 18 of these instructions, under Part 7, Protecting Oneself in Pressure Situations in Criminal Proceedings, one essay in particular, How to Sign Your Signature Without Liability, proves utterly the correctness of what we are doing in this manual. And that is a very, very good chapter, How to Sign Your Name, Signature Without Liability. I made a video on it on this channel. I have a whole video. I read it, and I did a nice video just on that section of how to sign your name without liability. That is something everybody who listens to this should know how to do. You should know how to sign your name whenever it's required you to sign. You just signing your name as a blank signature. You're just giving them permission to do anything they want with your signature. Your signature is the most valuable commodity that you have in commerce. You need to become an expert with it. Assalamu alaikum, rahmatullah, barakut. Question, is Gene Keating classes still available? And ask you for being a big uncle to us. And thank you. Okay, I couldn't see right. I can't see it real clear. But assalamu alaikum, brother. The thing is, Gene Keating was, Gene Keating was very sick and ill. I don't know if you're asking about the classes he used to have. I don't know. My answer to that would be I don't know. All I can tell you is the last time I heard was that he was very ill, and that's all I know. I haven't heard anything in a while, and that was some years ago when I was hearing he was ill. So I don't know. Then I hear every now and then I hear something he's still around. I hear that every now and then somebody will come and say it. So I don't think he passed away. But if he is doing his classes, you can hunt it down, let us know. You know, he was doing classes for like $25 a session, you know, at one time. That was a long time ago. I don't know if he still does that. But, you know, he definitely is a person that has a good source of information. If you get any of his material off the internet, you should read all of it and digest all of it. Because if anything, it can guide you in the right directions as well. He may not have all the answers, but he can definitely put you on the right paths. Okay, thank you for that citation, Jefferson Tree. And Court versus Natural Resources. I appreciate that. All right, brother. Got it. Okay, let's get back. All right, so how to sign your name without liability. So let's get into this. Okay. Creating your response documents for handling presentments. All right, now this next section tells you step by step what you're supposed to do. It tells you step by step what you're supposed to do. And I'm doing this because I want to see people. A lot of people say, "Why you charge for information?" At that, no, we don't charge for information. We charge for reading stuff for you. That's what we charge for. Because we tell you what to read. If you don't read it, you come to us, you get charged. All right. So we are charging you for us reading for you and coming back and explaining it to you. That's what you're getting charged for. All right. So now I'm reading it to you so you can understand what it's talking about. Because I do understand how it is confusing. I don't expect you to read all of this stuff and understand it the first time, because I didn't. It really didn't, but it will at least if you read something and you don't quite understand all of it, okay, understand that everybody's like that. To master something, you have to read it at least 7 times, because the brain cells have not formed in a particular pattern where it's receptive to the information. That's why you got to read it over and over again, and then you'll reach the aha moment where your brain locks in, and now you understand it. You got to see, the way the mind sees is kind of like this test they give you when they say, look at this piece of paper with all the colors on it. It just looks like a piece of paper with a whole bunch of different colors on it. And I ask you, do you see the dog chasing the ball? And you don't see it. Then I say, well, keep staring at it. And then you keep staring at it. And then all of a sudden, a picture of a dog chasing a ball pops out. And that is because nothing on that paper changed or rearranged. What changed and rearranged was your mind attempting to reinterpret in a way that makes sense the information that it's seeing. The mind, you see with your mind, not with your eyes. The optic nerve is connected to the brain. You see with your mind. That's why I have a mind's eye. You don't see with your eyes. You see with your brain. Your eyes are just the windows. Your brain interprets what you're seeing. That's why you can teach yourself to see into the invisible realm. It's just a matter of changing your perception, of practicing to help your mind reinterpret what it's looking at. That's why the Matrix was so cold. That part in the Matrix where Morpheus and Neo was having the discussion, and he said, "What is real? Is that air you're breathing?" He's talking about, the mind interprets everything. What's real? Everything is just the reason that they call everything an illusion or Maya is because it's all composed of electrons, protons, neutrons. Everything is made out of the same stuff. It's just being formed in different patterns, different vibrational frequencies. And you can change those frequencies if you know how with your mind. The mind is master of all of this. That's why they say he who controls the paradigm is God. Because if you allow somebody to form perceptions for you, they become your God. You got to form your own perceptions about things. You can't allow somebody to influence you. You got to be the master of your own mind. You have to make decisions for yourself. And the only way you can make proper decisions is based off proper information. And proper information has to be rooted in natural law principles. Peace to the gods, brother Yusef. Where can I find the recipes you use for your homemade juices? I don't have any written down. I just kind of watched the YouTube videos, and then I just kind of the first rule is make sure green matches green. All the colors match. When you juice something that it can be close, like a red apple and a carrot. And an orange can all go together, something like that. But for the most part, you want to get the sense that, you want color, you do color matching. And once you do color matching, then all you're getting in is to the amounts. But you'll learn it when you just get into it. Maybe I do need to put together a recipe book. I don't know, because I love the juice. But anyway, wisdom calls out to anyone who has ears to hear. I'm doing the secure buddy process, and I thank you for all you do. to free us mentally first. Then we utilize, we see the results physically, and we sign everything without prejudice, UCC 1-308. Yes, and you don't have to say UCC 1-308. You could just say without prejudice. You know, you don't have to put UCC 1-308. And a lot of times I wouldn't because, well, it doesn't. It just depends on how you choose to proceed with your remedy. You know, you can get commercial remedies. That's what we're discussing right now. That's why you say UCC 1-308, because we're doing everything in commerce, but there are common law ways of doing things too, you know, and you can learn both of them. This is a very, very broad subject, and it requires a lot of study. That's why I elected to do a school instead of just going out there peddling remedies and things like that, because this is something that needs to be done. People need to be taught the fundamentals. That's the problem I see what's going on out there. Ain't no fundamentals. Ain't nobody out there teaching fundamentals. But, okay, so we're talking about handling the presentment. So demands for acceptance. Such presentments are generally from government agents and officers, but can also come from attorneys and individuals, citizens of the United States trade names, and basically constitute unauthorized use of your common law copyrighted property. Regardless of the fact that there may be potential criminal penalties and fines associated with the presentment, if from a government actor, you have the unalienable common law right to demand and obtain compensation for the unauthorized use of your property as set forth in your published copyright notice. This is strictly a private matter between you and any party who is using your property for financial gain without your authorization. And as I said earlier, this is dealing with common law copywriting the name. This is an old school remedy type thing, but I think it's very good for people to be aware of it and at least be educated on it, because it teaches you a lot of fundamental principles. For one, how to do an administrative process, how to put together a security agreement, how to really to put a lien against somebody, like the basics for it, notice requirements and things like that. So notice by written communication / security agreement. See, you have to have a contract. So since these people want to use your trade name, then that means that's an offer to contract, but that's a contract implied. We're going to make an express contract and make an offer to them. If you want to use my trade name, well, here are the conditions for such use, because I haven't given you authorization to use it. Once again, we're talking about commerce. Keep your mind rooted. We're talking about business. I want to keep your mind right there. Don't let it wander nowhere else. Root your mind strictly in business. And this will help you become a good business person. It will. It's the foundation for becoming a good man or a good businessman or woman, because it teaches you good principles. It teaches you good principles. So the first thing you're going to do is a notice by written communication / security agreement, entitled in non-judicial terms so as to align with tenets of the Uniform Commercial Code. The notice by written communication / security agreement, hereinafter notice by written communication, is recommended for handling non-pecuniary presentments, namely demands for acceptance. The document is self-explanatory, contains no judicial / statutory jargon, consists of everyday common law language, is written with a mind toward augmenting the non-judicial foreclosure process of the UCC once the debtor defaults on payment after being invoiced for the charges in the form of a verified statement of account, the private equivalent of a grand jury's true bill. And this is why you have to build them, and it teaches you how to do that. You got to understand, they're utilizing your time. You only got a certain amount of heartbeats and breaths on this planet. And if anybody comes and infringes upon that, they owe you something. Your time. Time is that priceless commodity that very few people use properly. And when you think about it, it's the only true personal property. Don't fuck with my time. You messing with somebody's time, you messing with their life. You taking something that can't ever be got back. Sit back and think about that. Sit back and think about that with taxes. Just sit back and think about that. how different, very nefarious and slick ways people can steal your time without you being aware of it. And them the one you got to watch out for. They stealing your time and you're not aware of it. Like a traffic ticket. A traffic ticket is stealing your time. If you work 40 hours a week and your check is $2,000 and you get a traffic ticket on the way home and it's $1,000, they just took 20 hours of your time. They just took 20 hours of your time. What? That's not important to you? If that's not important to you, you don't care about your life. Maybe you don't have as much self-love as you think you do. Oh, shoot. That's exactly right. Billable hours. Thank you. I'm looking in the chat. I'm seeing some people in the chat. Get it. Billable hours. Exactly. That's my time. You got to pay me for. That's why everybody want to get paid for their time. Everybody want to get paid for their time, man. You taking people's time. Time is important, man. And as the older you get, the more you realize how more important it is. You realize, as you get older. All right, so let's look at number 2. So the first document you're creating is a notice by written communication / security agreement. The second one is converting sample document. Okay, because you got samples that are going to be used all through here. So as with all of the documents in this manual, there's no other way to generate your personal notice by written communication on your own other than going through the sample document word by word, learning as you go, and replacing John Henry Doe's information with yours. Let me tell you this. You don't put your name on nothing unless you understand what every word in the document means. Why would you sign your name on a piece of paper and there are words in the document you don't know the meaning of? What if one of the words say that you agree to give your life, your heart, or kidney, or something like, you know what I'm saying? Or you agree to this, you agree to go to jail for 20 years, or whatever. It's a word in there, you don't know what it means. And you signing a piece of paper. That's why most people are having problems, because they sign a contract. It's really people, they say, when I want to get out of something, what they're saying is they want to get out of a contract that they didn't already agreed to. By implication or expressly by signing your name on something. Implication means conduct. You acting as if you're in a contract. All right. Let's look at number 3, mode of sending. All right, we're going to also learn how you mail documents as well. How you mail the documents off with certified or registered mail. That's a private way of communicating through the mail, especially when using certified or registered mail or restricted endorsement. We use registered mail, sent restricted delivery, return receipt requested, the green card, the 3811 form, with an affidavit of service exclusively, but as always, final choice rests with you. And I'm gonna tell you, if it's important enough, you always use some sort of affidavit of mailing. The reason why is when you get into some sort of argument with someone and there's a possibility it's gonna go to court, you need to immediately start taking steps to start accumulating evidence. So you need to know the rules of evidence. Evidence require witnesses. Evidence has to have witnesses. So the post office is a witness and notaries are witnesses. That's what notaries are. They're professional witnesses. And your 3811 form is a witness. 2 witnesses. Where does that come from? Out of the Bible. The judge is in a robe. They used to bring the Bible into the courtroom and make y'all swear on it. They stopped doing that. The damn courtroom looked like a church. Tell the truth. Where did they get that idea to make the court look the way that it does? I want people to understand that the reason I'm bringing all this to your attention is I want you to understand that they're trying to convert everybody in America to heathens. They have the permission to enslave heathens. That's in Leviticus 25:45 of your Bible. A heathen is a person that don't believe in God. One of the pillars of the Communist Manifesto is the elimination of religion. This is why they don't want to read it. They want to read it to y'all because y'all going to see y'all like, what, nigga? It's going to have something like, what you talking about? What is this they trying to get us into? You're going to start asking serious questions, especially when somebody just publicly admits that they're a Marxist. It's going to make you really start looking at them side-eyed. Like, you're a damn traitor. You hate America. That's what you're saying. You hate it. I don't hate my country. I don't know about y'all, but I don't hate my country. I don't care what problems that we have in this country. I don't care about the racism. I don't care about the crime. I don't care about none of those things. I love my country because this is where I was born. And because I was born here, if you want it to be a better world, then you need to take the steps to make it a better world and stop thinking somebody else is going to come and save it. Because the helping hand you're looking for is at the end of your arm. And it's only when we, as a people, come together will things change and have a different paradigm of the way that this country should be. Me traveling throughout the world, traveling the world, it opens your mind. Some countries I went to reminded me of America 30 years ago, 40 years ago. I'm like, damn, man, this is very nostalgic. I like this. I like how the men and women treat each other here. They both respectful to each other. I like that. I think that's what all men want and would want. I don't mean men don't want to run over women and shit. Men want to have a respectful relationship with a woman. That gives us joy. We don't want to disrespect our woman. And when a woman acts like a lady, how you going to disrespect her? You know how hard it is to disrespect a lady? You know how hard that is? You got to be a king-size asshole man where other men are going to look at you, probably want to whoop your ass. That's the danger you take when you disrespect a lady. Let's get back. So we're going to use the green card, and we can use registered mail, but you can use certified mail in some instances when you're doing your administrative process. Important, optional text in 2 segments. There are only 2 versions of procedure for opting out of consensual contract. Now what this is you're giving them, this is almost like a conditional acceptance, or you're allowing them an opportunity to get out of it. You're trying to hold them harmless. If you turn around and leave now, ain't no problem. You go your way and I go my way. But if we study history, we can see that that is not the nature of these people, especially when we go back and look at World War I. When Great Britain and France attacked Germany without provocation, based off the fact that they was making money. They was just pissed, they were jealous of them, like, damn, these niggas over here getting bread. And they make good products. They're going to take over the world. Let's go fuck them up. It's just people like that, man. It's just people like that. You got to accept that. The world's not perfect, but you guys got to accept it's just going to be some people. They just not going to turn and go around to their corner and can say it's all good. Somewhere in the back recesses of your mind, they think they can get you. They think they can get you. They think you soft. Or they think you dumb or something like that. And that's why you have to arm yourself and gird yourself with information because you're going against these kind of motherfuckers. They think, nigga, I went to 3 years of law. Nigga, I went to undergrad, 3 years of law school, and I've been in my profession 15 years. You can't fuck with me. You got people, and which they right in a sense to a certain degree. But law is pretty simple. It's based off basic principles. You learn those principles, you don't have to know everything that they know. That's a lie. You do not have to know everything they know. You just got to know a few principles. There was one of the first Supreme Court justices, I can't remember which one it was. He gave a speech in front of law students, I think in Philadelphia. I forgot what university it was, but one of the students asked him a question. He said, hey, how are we going to learn all this? You know, it's such broad, it's so much information. He was saying, you know, you don't need to study the information, you need to study the principles. You see, principles are few, methods are many. You study the principles. That's what's going to guide you back to the Creator too, because principles come from the Creator. That's why they call them equitable. Only way that you can be governed righteously is through God's laws or any man-made laws that are in harmony with God's law. That's the only people that have a right to rule or to have any type of authority. $5. Thank you for the $5. Lost Roads. Peace, Yusef. Any advice on how to deal with an attorney? I was in a car accident with a private company, not sure to go about it. I mean, I don't know. You know, did he write you? You know, usually when you start dealing with an attorney, it's going to be through some written correspondence. You got to know how to respond to them. They basing everything off the fact that you won't respond because silence is acquiescence. Most people, when they start having to run in with an attorney, they get scared. They get a letter in the mail, they get scared. I got this from a lawyer. You don't get nervous on that. Read it, see what it says. See what it is that they're offering you because they're going to be making an offer. And then, you know, if you want to counteroffer it or you don't think they have no legal basis for making a claim, then you just address it accordingly. You know, I received your correspondence, but I failed to see where I have any obligation, you know, to act under, you know, under this, you know, with your, you know, in any kind of way. I don't have a contractual relationship with you. If you can demonstrate one to me, I'll be glad to take a look at it. But right now, with your present correspondence, I don't see anything in this correspondence that would allude to that. You know, just things like that. Now, that's just coming off the top of my head. But, you know, you just, you know, you have to write back. And it's optimal for you to write back within a certain amount of time. And usually if you let guide you 10 days, meaning 3 days mail time, when something is mailed to you, you give it 72 hours. And then after you get it, you got 72 hours before a contract is formed. And then you got another 72 hours return mail, and then 1 day for Sunday. That's why everybody talk about 10 days. But it can be other than 10 days, but that's like a standard. And you should guide your life by that. When you get something in the mail, you got 10 days to respond. There are exceptions, like under the Fair Debt Collection Practices Act, I believe they have like 20 days to respond, or if you're going through the Federal Rules of Civil Procedure, something like that. You know, there's some other guiding rules that regulate the activity. But generally speaking, you can't go wrong if you just live your life according to the 10-day rule. Even if they say in their correspondence they're giving you 30 days, you still do it within 10 days. You're going to find that you're going to get different type of responses when you do things different kind of ways. Once you learn the nuances of all of this, instead of just blindly following what somebody tells you to do. Nothing can trump something that is written by you, from you. When you do paperwork for yourself, that's the highest form of paperwork you can do. It was by you, meaning you were the one who wrote it, and it's from you, which means it's from the essence of you. It's from who you really are. But that question, who are you? Who thyself, and to thyself be true. You're going to start to see that all around the world, these same esoteric things are being honored. They just being spoken in different ways. It's called a declaration because you're declaring to the world who you are. That's why you do things by declaration, because no one can tell you who you are. The only person who can tell you who you are is you. That's why we call you a sovereign man and woman. What do they mean? Are they trying to have some sort of implication that we're not sovereign, that human beings are not sovereign individuals? That right there are the thoughts of a communist and a Marxist. That's how you can identify them. If they have a problem with you calling yourself a sovereign. That's the first red flag. Okay, important optional. So you're giving them an opportunity to opt out. So, okay, I'm gonna give you this. If you don't want to go through this and you want to end it now, go our separate ways, here's a opting out consensual contract. We're going to settle this out of court, basically. There are two versions of procedure for opting out of consensual contract on page 2 and a subsequent segment entitled self-executing security agreement. You have to have a self-executing security agreement. There has to be some sort of contract. And the terms of this contract tells them that if they don't take certain action, okay, that this contract is going to self-execute. They will argue that they're not obligated under it. I would argue against they're not, because they're seeking to contract with me or get something from me. I guess the question that ultimately comes down to, is this public or private? That's why these are all private processes that we're doing. They can't tell you how to do a private process. It ain't none of their goddamn business. Because under the Constitution, they can make no law that will infringe on the obligation of contracts. Contracts are for us, private people. And you have the right to contract unlimited. You will need to choose between the two options each time a presentment comes your way. Basically, the first one gives the unauthorized user a quick and easy way out, with no muss and no fuss, thus ending the confrontation. The second is far more stringent and really puts the unauthorized user in a pickle, and it is doubtful if he or she will get out of it. Note, you're not prohibited from adjusting this paragraph however you see fit. But if you make changes, you should be absolutely certain that they do not contain any statutory/judicial language and that the parameters that you set are within the UCC for non-judicial foreclosure, also known as strict foreclosure. And these are private processes. You can use the principles that are used. See, all law is based on principles. So when you look at something in a statute, there's a set of legal principles or lawful principles that are used, and you just use those same principles and you form yours on the private side. Everything is guided by principles of law. When they come down to start using private script like Federal Reserve notes, they bring themselves down to the level of a private person. What is that case? Somebody knows what I'm talking about. I can't think about it, slipping out of my mind, that talks about that. So you're dealing with another private individual. When they using Federal Reserve notes is not a governmental entity. Federal Reserve notes is a private bank. They're using Federal Reserve notes, and we're using Federal Reserve notes. They're not operating under the public, under the Constitution. They're borrowing from some foreign entity and conducting commerce against us, just like we can do the same thing. That's why everybody want a Treasury direct account. Because what you're saying is, shit, I don't need you to do this. I can do it myself. I can go directly to the source. I know how to put together a bill of exchange. I know how to put together a promissory note. I know how to construct a bond. What do you mean? You trying to tell me I can't put together a negotiable instrument when negotiable instruments came from us, from private merchants? You got it from us, and then you're going to turn around and tell me I can't create a bond? No, I'm more than competent enough to handle my own commercial affairs. Thank you. So let's keep going. Okay, so so here is some of the verbiage that would go into your opt-out procedure that you would use. So this is just giving you an example of some of the terminology that you would use in your contract, and you can choose to use it or not. But they give you, and it's good to read this thing, this stuff, because in reading it, you're training your mind how to think in terms of, this is why they think everything is so strange. When you look at people in the public and they talk about these processes like gobbledygook and all this kind of stuff they try to say and all this old bullshit, that's because they don't understand principles, or they do understand principles and they think you don't, so they try to act in the public like it's some nonsense. When it is following a principle, they understand what silence is acquiescence means. But when it comes time for it to be enforced, you're trying to act like it don't apply in this situation or something like that. When that's a principle, that's an equitable principle. Procedure for opting out of consensual contract. Jack Jones' unauthorized use, namely counterfeiting a secured party's common law trade name / trademark and copyright, consensually contractually binds Jack Jones with the secured party. As of Jack Jones' initial unauthorized use of secured party's common law trade name / trademark and copyright in respect of fair compensation due secured party for use of secured party's private property, Jack Jones can opt out and withdraw from Jack Jones's consensual contract with secured party and retain no obligation associated therewith, only by immediate cessation of any and all further unauthorized use of secured party's common law copyrighted property. Self-executing security agreement. By the act of any single instance of unauthorized use of secured party's common law copyrighted property by Jack Jones, following Jack Jones's receipt of this notice by written communication, Jack Jones, hereinafter user, only in this self-executing security agreement section accepts the obligation of this consensual contract. This notice by written communication concomitantly becomes a security agreement, hereinafter security agreement, wherein user is debtor and John Henry Doe is secured party and user. This is just verbiage, and you get practice reading this. And as you read it over and over and over again, it starts to become second nature. You start to kind of see things and speak things in terms of legal and kind of legal. You know, that's not just a lot of gobbledygook, it's covering a lot of bases. It's verbiage that covers a lot of bases. All right, so right here we have the procedure, difficult opt-out procedure with subsequent self-executing contract. The time period referenced within this segment is the 72-hour Regulation Z Federal Truth in Lending Act period that is initiated when someone voluntarily incurs an obligation. The party has 72 hours from midnight of the day after execution of the transaction to back out of the deal. See Truth in Lending Act and glossary for the act in pertinent part. Now, that 72 hours is what I was explaining to you earlier. You know, they used to have, like in some states, like in Georgia, they don't have a cooling off period anymore. The contract is immediately, honored. But there is this common law way. This comes from the common law, 72 hours before a contract is formed. So right here, this is some verbiage you can use to make it even more difficult. So, I'm sorry, I got something in my mouth. Jack Jones's unauthorized use, namely counterfeiting of secured parties' common law trade name / trademark and copyright, consensually contractually binds Jack Jones with secured party as of Jack Jones' initial unauthorized use of secured parties' private property in respect of fair compensation due secured party for use of secured parties' private property. Jack Jones can opt out and withdraw from Jack Jones's consensual contract with secured party and retain no obligation associated therewith, only by Jack Jones's delivery at the herein above designated mailing location for secured party no later than 12:01 a.m. of the 5th day following Jack Jones's receipt of this notice by written communication of any and all original instruments, documents, and records in any form of recorded media whatsoever, as well as any and all copies of all originals in any form of recorded media whatsoever containing both the signature of Jack Jones's and any counterfeit version of either of, number one, secured parties' private common law copyright trade name / trademark, namely namely John Henry Doe, secured parties private, autograph, common law, copyrighted property, named John Henry Joe. I kind of like that. You know, you requesting all the property, anything with your name on it out of their files, give it to me. I want everything you got. Get it out of your computer databases. This is when you kind of learn you on another level. You start doing stuff like this. It says, absent Jack Jones's surrender of all original instruments, documents, and records in any form of recorded media, as well as all copies of any such original containing Jack Jones's signature and any version of any of secured parties' common law copyrighted property, as set forth above under a procedure for opting out of consensual contract, Jack Jones, hereinafter user, only in this self-executing security agreement section accepts the obligation of this consensual contract at 12:01 a.m. on the 5th day following the user's receipt of this notice by written communication. This notice by written communication concomitantly becomes a security agreement hereinafter security agreement wherein user is debtor and John Henry Doe is secured party and user. This is set in the contract that you're going to file in the UCC, because to file a UCC-1, you need a contract. If there's going to be a creditor and a debtor, there has to be a contract. And there are different ways of getting into a contract. Don't let these people fool you. Validation of debt package. This is usually like you dealing with a mortgage or a situation or something like that. You usually want to verify the debt in order to make it valid. There's a verification of debt and a validation of debt. They are not the same thing. Verification of a debt is requesting that someone provide an affidavit attesting under penalty of perjury that they are indeed a creditor and you are a debtor with an obligation to perform under some contract with them. Because that's the right thing to do. If they say they right, they shouldn't have a problem doing that. A deceiver speaks in generalities. That's a maxim of law, in case you're wondering. The deceiver speaks in generalities. Let's get specific. First of all, you need to attest under penalty of perjury that what you're saying is true, correct, complete. So help you God. That's how the courts operate. What do you think it is you have to swear when you get on the stand? What do you think it is when you go on a deposition? What do you think you're doing when you present affidavits? Everything had to be attested to under penalty of perjury. So we want to verify the debt in order for it to be valid. 15 U.S.C. 1692G, I think, of the Fair Debt Collection Practices Act. Look for the word verify, and then look up the definition of verify. So you won't have to wonder if you're doing something right. You'll know you're doing something right. All right, that's it for today. I'm going to stop at validation of debt package. I'm going to do this tomorrow. I'm gonna do a little bit of this every day is what I was planning on doing, is just doing a little bit every day, just getting on, reading things to you, letting you get some understanding of the information, kind of, fertilize your mind so it gets ready to really accept some seeds and really begin to grow. They're just making fertile soil for the other information that's going to come, So I want to thank everybody. I want to thank everybody who tuned in, the donations. I appreciate you. And I will be back on again. What time is it right now? Okay, yeah. Again, I've been on about 2 hours. I'll be back on again tomorrow, and we'll do this thing again. All right? Like, comment, and subscribe. If you're not a subscriber, hit the notification bell, so you can get notified. I try to give y'all an hour's notice before I go live. I try to almost give you an hour, notice before I go live. So, be looking for that. Join our email list. That list is under the video. You can join that. And peace to the gods. I'll see y'all tomorrow. Peace. I'm out.